Welcome to Inside IR, a podcast series by Herbert Smith Freehills that explores the latest developments in the Australian industrial relations landscape.
Hello and welcome to Inside IR, the Australian Industrial Relations podcast, the series that arms HR, IR and legal professionals with the latest industrial relations thinking. My name is Rohan Doyle. I'm a partner in the Industrial Relations team at Herbert Smith Freehills, and I'm joined today on our next episode of Inside IR by partner Nick Ogilvie and Vic Fijalski. G'day Vic and Nick.
Morning.
Or afternoon, or depending on when you're watching this podcast. It's great to have you back on Inside IR, no strangers to Inside IR. And I'm very excited about today's episode, actually. It's a topic that clients have increasingly been raising with us. There's a lot of interest in it. It's an area we've previously touched on Inside IR, and it's an area that is having a really significant impact on tactics and strategy of enterprise bargaining. It is, of course, the intractable bargaining regime. At the time of filming, we've now seen 5 applications for intractable bargaining declarations. 4 of those have been successful. And in light of that, we're starting to get a good sense for how the Commission's approaching those applications. The 4 that have been successful, of course, involve bargaining rounds with Fire Rescue Victoria, Cleanaway Erskine Park, Cleanaway Unanderra, if I pronounced that correctly, and Network Aviation. The one that has been unsuccessful is, of course, the bargaining round involving Ventia. With the 4 intractable bargaining declarations that have been successful, the other benefit we now have is that we've got those 4 bargaining rounds that are proceeding through the workplace determinations process. And we're learning a lot about how the Fair Work Commission is approaching those proceedings as well. At the time of filming, all those proceedings are still live, so the Fair Work Commission is yet to make a workplace determination. And what we're seeing is that they've all been pretty contentious. We've had quite a large number of disputes in the early phases of those workplace determinations proceedings about what has in fact been agreed and what hasn't been agreed in the lead up to the intractable bargaining application. So the parties can't even agree on that very basic proposition at the start of those proceedings. So importantly, there's been many more applications that we know of. They're just the 5 applications that have had written decisions. We know there's been more. There's also been many more threatened. And in our experience, these laws are having an impact. They're encouraging the bargaining participants and in particular employers to make concessions. They're getting deals done.
Looks like of the new changes, it's probably the most impact immediately compared
to I think that's right. Yeah,
it's most immediate impact.
Yeah, absolutely, and for reasons which we'll explore on the podcast today. So, for that reason, Nico, there's already been a whole stack of learnings to take out of those 4-5 different proceedings. Lot of learnings and a lot of tips for employers. So, in light of that, what are we going to do today? We're going to cover 3 things. First, we're going to kick off. Vic, you're going to take us through a bit of a recap. What is intractable bargaining? What are the preconditions for making an intractable bargaining declaration? Second, we'll get into the practical stuff. What are the key traps for employers? Now, we've scoured the case law and also in light of our own experience in advising employers about these proceedings, we've gathered the 5 key traps for employers. We'll take you through those mistakes that, if made, are going to lead to some pretty poor bargaining outcomes. And we'll also share our tips for avoiding them. We're all about solutions on Inside IR, so we'll come up with a few of those. Yeah, that's right. And that's finally, third, Nico, we'll come to you, the big burning question. Is there any upside in the intractable bargaining regime for employers?
I'll hold my answer just till
just keep us in suspense, Nico. We're looking forward to that one. So, without further ado, Vic, let's get started. What is the intractable bargaining regime?
Sure. So as we know, the consequences of the Commission making an intractable bargaining declaration is that it kicks off the process for making an intractable bargaining workplace determination. That's essentially an enterprise agreement that's arbitrated by the Commission. So when can an IBD be made? Well, an application must be made by a bargaining representative for the proposed non-greenfields agreement that's usually made by an employer or a union. The parties must have bargained for 9 months post the notification time for the proposed agreement, including 9 months after the nominal expiry date of the existing agreement. And the Commission must have dealt with the dispute about the agreement under its 240 process. The applicant must have participated in that process And what we've seen from the Commission authority so far is that the 240 conference needs to deal with the core issues that are in dispute between the parties. There's no set number of conferences or certain ways the Commission needs to deal with the dispute. The Commission needs to be satisfied that there's no reasonable prospect of an agreement being reached absent an arbitration and a declaration. And the Commission authority has confirmed that their test does not require a finding that there's no prospect of an agreement being reached, nor does it require a certain or concluded determination that an agreement cannot be reached. The Commission also needs to be satisfied that it's reasonable in all the circumstances to make the declaration, taking into account the views of the bargaining representatives. And what we've seen so far is that it's probably fair to say the views of the union bargaining representatives will hold significant weight, including whether or not the application is contested. And once the Commission has made the IBD, subject to any post-declaration negotiating period,
That's a mouthful.
it is, which have generally been between about 13 to 21 days, but that will depend on the parties' preferences really. A full bench of the Commission must make a workplace determination as quickly as possible.
It's quite ironic that you have a post-declaration negotiating period when the Commission has already decided that an agreement is not reasonably likely, but anyway, I don't hold out much hope for those processes.
It's an interesting dilemma because the Commission's trying to determine that they can't be agreed, then trying to make the parties agree. So maybe it's to narrow the issues. There must be some purpose to it.
Yeah, of course.
Yeah, and so what we've seen in some cases is that it's been used for the parties to try and reach agreement on what terms are agreed for the purposes of the arbitration. The only final point I'll say on the IBD and the consequences of that being made is that on the day the declaration is made, all protected industrial action must cease. So that's a key thing for employers.
Great, thanks, Vic. So you see, it's quite a process. There are a lot of preconditions that need to be met, a lot of bargaining to go under the bridge before you can actually get to a potential intractable bargaining declaration. Now, with that in mind, let's get into the practical stuff.
Yep.
The 5 key traps for employers in intractable bargaining. Nick, do you want to kick us off with number 1?
Thanks, Rohan. So number 1 is trap 1 is underestimating the bargaining timelines and the impact of protected industrial action. So as Vic mentioned, it's really a 9-month period, either post the expiry date of the agreement or 9 months worth of bargaining before you can even have access to this the intractable bargaining declaration. And that's a long period of time. You think about 9 months actually heavy bargaining. No reasonable prospect of reaching agreement is one of the tests. And so obviously for the Commission to form that view, it needs to be involved in the process, it needs to be educated about what's been going on, has to have either evidence or an understanding of the parties and their involvement in that process. So if you look at the number of conferences, I think you mentioned that there was a wide range, most of the successful intractable bargaining declaration applications had a number of conferences, even up to 11 before they got to that point in time. So, and individual Commission members being heavily involved in that process. And at least what we've seen from the cases, from the 4 successful ones at least, and even the unsuccessful one, there needs to be a vote of employees, and that needs to be at least be seen to be a test of whether the offer can be accepted or not. So the bargaining representatives might not agree, might even agree to put the vote to employees, but there needs to be at least one testing of the wards to see whether employees agree or not. I think in one of the cases, I think the Venture case, the third vote was actually worse than the first vote. So.
Yeah, Network Aviation, I think, had four unsuccessful votes, which it makes sense that the Commission would expect, and this isn't an express condition, but the Commission would likely expect the parties to have tested the deal with the workforce before reaching a view that agreement's not reasonably likely.
And you're right, it's not expressed because the regime focuses around the views of the bargaining representatives, but in Network and in others we've seen groups of employees, the deal was agreed by the bargaining representatives, but the vote was actually voted down by the groups of employees. So it's another sort of element you need to consider, taking that into account. The other part of the test that Vic mentioned needs to be reasonable in all the circumstances, taking into account the views of the bargaining police. So obviously it's going to be harder to get an order made in circumstances where it's opposed by one party or another, or one bargaining representative or another. So that again, unsuccessful votes will feed into that reasonable requirement as well.
Well, just on that one, Nico, just having a look through the cases that have been determined so far, it's interesting that only one has been fully opposed by a union and that is the one that was unsuccessful, and IBD was not made. It's the Ventia application.
And it's interesting, even you think about the 9-month period and being able to withstand protected industrial action. The Ventia case was one where the industrial action wasn't significant in the scheme of things, and the Commission thought there would be an ability for parties to go back and maybe reach agreement in the process, part of that process. So putting the parties back, pressure back on the parties to use the existing tools rather than coming to the Commission for help in the process. And so again, so it's likely to, the answer to that, the result of that is it is 9 months, but it can be a lot longer. If you think about how much the Commission needs to be involved leading up to that process, the 240 applications, whether or not there's been a vote, whether there's been protected industrial action, you need to be able to, it is a mechanism to relieve some pressure and to stop industrial action, but you might have to withstand a fair bit of protected industrial action before you get to that process.
Yeah, no, it's a really good tip, Nico. So don't underestimate how long it may take to get into intractable bargaining. It's not necessarily an easy, quick solution for employers or the union. It's going to require time, and it's going to require the employer to be in a position to withstand that industrial pressure throughout the duration of that process. Great first trap and tip, Nico. Vic, that brings us to number 2.
So trap 2, your existing enterprise agreement terms. So the Commission must include in any workplace determination terms that deal with the matters still at issue, and they must include any agreed terms. In relation to the matters still at issue, employees can't go backwards. So we've discussed this in previous episodes, but it's worth noting again that in making a workplace determination, the Commission is prohibited from including a term or condition that is less favourable than the existing terms and conditions in an enterprise agreement that applies to the employees and deals with the same matter. This doesn't apply to wage increase terms or agreed terms. And the Commission considered the no less favourable requirement in Cleanaway, the Wollongong matter. In short, in that matter, the TWU sought to maintain Monday to Friday span of ordinary hours that was in the current agreement, and the company sought to extend ordinary hours from Monday to Sunday, with an option to elect to work ordinary hours Monday to Friday. They also sought to increase the maximum number of ordinary hours that could be worked from 8 to 9.5 hours per day. So the company claimed these changes would not be less favourable, as they would, for instance, provide employees with choice, flexibility, and they also argued it might increase female participation in the waste management industry. The full bench ultimately didn't agree. It found that the company's proposal to extend ordinary hours would be less favourable than those in the current enterprise agreement, with employees essentially losing out on overtime.
And there was evidence from the employees, individual employees, about the impact on them personally and their ability to do the family duties and things during the weekends as well.
Yeah, absolutely. So the Commission then decided to replicate the ordinary hours term in the workplace determination. Interestingly, at the different Cleanaway site, that current EA actually provided for a span of ordinary hours Monday to Sunday, which Cleanaway sought to maintain. The TWU's claim in that was for the ordinary hours to be Monday to Friday. Cleanaway had actually had the ability to roster ordinary hours on weekends since at least 2010, but the uncontested evidence of the TWU witnesses was that it had not sought to actually do that or roster ordinary hours on weekends, except in a small number of cases. Ultimately, Cleanaway was successful there, and the Commission agreed to maintain the Monday to Sunday span, accepting that weekend work was likely to increase by 2025. So these cases do provide some useful guidance as to how the Commission will approach these issues and demonstrate that it's likely going to be difficult for employers to achieve certain changes in a workplace determination. So really the only way to achieve a change in an enterprise agreement that may be less favourable than a current term in an EA will be if the EA is voted up by employees, or if it's an agreed term for the purposes of an intractable bargaining workplace determination. That's why it's critical for employers to start thinking about their bargaining strategies, employee engagement, and what they want to achieve and how they can position claims effectively, which we'll discuss now in the episode.
It's a really good point, Vic, and I think this no less favourable requirement is something that flows into a range of the other traps that we'll come to shortly. And it is a serious impediment to what the employer might be able to actually secure in an intractable bargaining workplace determination, but it's not all downside. There's still at least three important ways that an employer can extract some leverage in that process and maybe secure some outcomes and actually build some risk in the process for unions and employees. Those three are, number one, as the Cleanaway Wollongong case makes clear, the no less favourable rule only applies to existing employees. What does that mean? It opens the door, at least in theory, for the Fair Work Commission to include in a workplace determination grandfathering provisions. So it may be that a particular rostering arrangement or term or condition will continue to apply as it does under the current agreement to the existing workforce, but there is some flexibility there for the Commission to decide on different conditions for future employees. So that's one area where there is potentially, in the right circumstances, some opportunity to convince the Commission to look at grandfathering arrangements. The second point of leverage is, again, as highlighted by the Cleanaway Wollongong case, is that the Fair Work Commission cannot include forced arbitration in the workplace determination as part of the dispute settlement procedure unless the employer agrees. That's even if the current EA includes forced unilateral arbitration as part of its terms. So again, lots of unions, employees are going to be quite sensitive to that particular issue. They won't want to lose the capacity to unilaterally push disputes into compulsory arbitration if that's a condition in their current EA. They don't have full control over that, the employer does. So that's something to keep in mind. The third point of leverage is wages, as you pointed out, Vic. Even though you've got the no reasonable test in relation to all other terms and conditions, wages is still very much going to be a hot issue to be determined in the context of a workplace determination. Now, if you take a scenario, let's say the unions and employees haven't been all that reasonable at the bargaining table. They haven't agreed to some important changes that the employer is seeking, changes that will help the productivity and efficiency of the enterprise. Maybe it's a roster change, maybe it's something else. If the employees and union resist those changes, that might give the employer a really good case to run in the Fair Work Commission that restraint should be exercised on wages. There should be low, or perhaps in the right circumstances, no wage increases as part of the workplace determination, particularly if economic circumstances are difficult for that enterprise. Now, I know that will be difficult, but there are going to be opportunities there for employers, in the right cases, who have done the right preparation to push these types of claims. So again, as you'll see from each of those 3 points, planning really is essential, because unless you have the right things in your employer log of claims, and unless you approach the bargaining and the preparation for it in the right way, these opportunities are simply not going to be available.
Because that's the key, isn't it? If you start putting something on the table, you need to be able to walk backwards from it.
Yes, no, exactly, which actually is a handy segue, Nick, to trap number 3. What do you have for us?
Trap number 3 is making concessions without a quid pro quo. So giving up something in bargaining without getting something in exchange is part of that process, a proper bargain. If we go back a step to what Vic talked about, the requirements, the agreed terms get included in the workplace determination. But the agreed terms are measured at at 3 different points in time, and they're cumulative. So what it's measured at, what's agreed between the bargaining representatives. So that means all the bargaining representatives at the time the application is made, at the time the intractable bargaining declaration is made, and if there is a post-declaration negotiating period, I get that right?
Well done, Nico.
At the end of that period, so in case there's been some narrowing of the issues between the parties during that negotiating period. So, and that's cumulative. So whatever's agreed at those various times, one adds to the other. So,
and it has to be agreed by all the bargaining representatives.
And you've seen that being in network aviation in particular, and a couple of the others where you've got multiple bargaining representatives. It's difficult to show that all the bargaining representatives, if there's 3 unions representing the parties or 3 unions plus individuals, all those bargaining representatives have to agree. So it makes, in the circumstance where we talked about you can't go backwards and no less favourable, it becomes very important to think about what, if you are trying to make changes to your agreement, or you want to implement a wage freeze, or you want to make significant changes otherwise, what is it you're putting in, what is it you're getting in exchange? Because if you agree on that matter without any, it forms part of the agreed terms, which will go into the workplace determination. And we've seen that, for example, where our employers put a position in a agreement out to a vote, and it's been accepted as a baseline going forwards. But you can put it as a condition, but the conditions need to be genuine. And what we've seen from the cases, particularly FRV, Cleanaway, and then network aviation in particular, there's got to be justification. There's got to be a proper representation of what was agreed on the facts and the circumstances. So you can't just have a footnote that says, nothing's agreed till everything's agreed, or this is subject to the whole package being agreed. The Commission just won't accept that as a proper representation of what was agreed and not agreed during the process. So there's got to be clear trade-off between one element and another. So if you're putting a 3% wage rise on the table, that's conditional upon getting A, B, C productivity changes and being able to say, and have that quite consistent from the start. Just saying, well, we'll agree on a package of terms and we'll agree on wages later is not going to work in the Commission process. It can be very particular, and that was reinforced in the Network Aviation decision. You've really got to look at what's not just a footnote, but just actually properly what's agreed between the parties, what are the factual circumstances, but all the meetings, the conferences before the Commission, the deals you put on the table for a vote, what's actually agreed between the parties and being all the parties at the same time.
Yeah, I'm going to reinforce that one, Nico, because I think this is the biggest habit that employers do not currently have but need to build.
And that's been built into bargaining for 20 years, I mean.
Yes, but you know, it hasn't really been executed all that well in my experience. I mean, the key point is, because of the no less favourable test, employers really can't afford to give away any concession without getting something in return. And you ensure you get something in return, as you say, Nico, by making sure that you have some conditions attached to your concessions, and as you say, they have to be genuine. What we've seen in practice, though, is employers picking up, you called it a footnote, and just saying nothing's agreed until everything's agreed. That is not good enough, because as you see from Network Aviation, Commission's going to look behind that. They're going to see, is that genuine? Is the employer being real when they say that? The bargaining participants genuine, or is perhaps some of the concessions that you've landed on, maybe they're just concessions overall for all time. So what's the best way to do that, Nico? I mean, it's really to be specific about those conditions.
Right. And be specific from the start of your bargaining process.
That's right. So the employer, hey, union, I can give you X, Y, Z claims that you're seeking, but in return, what I need is A, B and C. And I need A, B and C because your claims are actually going to have a pretty negative impact on our productivity or efficiency or increase our cost base. And so to deliver those benefits, we need to do A, B and C. Now, if you do that, Commission straight away is going to go, well, that's obviously genuine.
Yep.
And if the union resiles on the quid pro quo, then clearly there is no agreed term, and that's going to be very relevant then to the arbitration that then ensues. Sorry, Nico.
Oh, it's just even at a really basic level. If you think of it, if you say nothing's agreed till everything's agreed, if you're rolling over the agreement, there are agreed terms. There's got to be agreed terms in the agreement. Yeah. So it can't possibly be that the heading and the dispute resolution procedure, for example, or other terms are not agreed. It's narrowing of those issues that are in part of the bargaining and being discussed by the bargaining parties. There's other stuff that's already agreed that will go into workplace determination going forwards.
Yeah. So the Commission's going to look at the whole bargaining process objectively and form an assessment based on each individual term. Is it agreed or not, irrespective of what labels the parties put on it? And Network Aviation tells us the best way to establish that is through contemporaneous documents. Sure. And that's another habit that really employers need to form, that some do okay, but most don't do particularly well, and that is the documentation of the bargaining process as it proceeds throughout.
And part of that, I suppose, is if you're putting a proposed agreement to employees to vote on during the process, what does that say that's agreed or not agreed? Is it, if you've not included that bargain or that trade-off as part of that agreement, does that mean that that's already agreed? Does that form the baseline? You just got to be careful about what you're putting to employees for a vote.
Oh, absolutely, because the Commission, I mean, whether it's then found to be an agreed term or not, It's going to carry a lot of weight, isn't it?
That's right.
And that's something that we've learned from the Cleanaway series of decisions, that the fact that the employer thought a particular wage increase was okay a few months ago and they put it to unsuccessful vote is pretty indicative that it's probably okay now. And the Commission's good chance they're going to actually put it in the agreement. Again, unless you can put some explanation and justification around why it was okay then but isn't now. And that's the discipline that employers are going to have to get into. That brings us to tip number 4. Vic, what's that one?
So trap 4, underinvesting in employee engagement. So the best way for employers to keep control over the process is to avoid third-party arbitration. How? Well, convince employees to vote the deal up. Sounds simple, but the only way to do that is to convince employees and perhaps the relevant unions that the deal on the table is better than what they could reasonably expect to receive from the Commission in an arbitration, and it's ultimately in their long-term interests and their employers' long-term interests.
I've seen that in one of the applications. I think the Virgin engineer's application, where the application for the intractable bargaining was made, but then the deal was done before the materials were filed.
Exactly, yeah. So it can be a useful way to get a deal done. So obviously this requires more than just saying so. Employers will need to ensure that they explain the reasons why, for instance, a change is required or why a wage offer is fair and reasonable. Employers should be able to justify their positions objectively and ideally have evidence to support their positions. This will depend on the claim, but for instance, it may be evidence of efficiency, productivity gains that may be achieved through introducing different rosters or changing ordinary hours of work. It could be comparison data of wages for employees, either at different sites or in different industries, and evidence of how work might differ between different sites, which justifies different pay and so on. This might help to convince employees, but it will also be essential, as we've just discussed, if it does get to the stage that you need to convince the Commission of your position in a workplace determination proceeding.
There's a bit of work involved in those things.
It is, and it will be completely dependent on your workforce, so it's hard to come up with examples of those. But back onto sort of the employee engagement side, employers should really start thinking about engagement well in advance of their bargaining rounds to ensure that their comms and their messaging to employees is consistent, and that they're actively communicating with employees and seeking their feedback and their views where necessary and where they can. Ideally, this should be occurring regularly throughout the life of the agreement and not just when the agreement is reaching its nominal expiry date or during bargaining. That way, it will hopefully mean that when an employer makes a claim during bargaining, it doesn't come as a surprise because the employer has been upfront about what's not working and what's working in the EA. Lastly, employers will also need to think about investing in the union relationship potentially. Having a union endorse a yes vote will often help to get a deal across the line, but of course, as we've spoken about today, being able to reach agreement with bargaining representatives on certain terms is now going to be very important for the IBD process.
That's really good advice, Vic, and a reminder that the objective is not to get into intractable bargaining. The primary objective is actually to get the vote up with the workforce. Plan B is being well positioned in the context of an intractable bargaining arbitration. And it brings me back to a point we made on previous podcast, Vic, that the actual objective with your workforce in bargaining is now different. It used to be you just had to convince the workforce that the deal the employer was offering was the best deal that was going to be available, even if they were subjected to industrial pressure. Now that's not enough. You've got to convince employees of that, but you've also got to convince employees that the deal on offer is also better than what they're reasonably likely to get in the Fair Work Commission if they pursue intractable bargaining. That's a very different question.
In the context of not going backwards as well.
Correct, yeah. Very different question. It requires different techniques with the communication and engagement that you're talking through, Vic. But as we've heard already with some of the tips and traps we've been talking through today, there are opportunities to create that leverage, to create that risk in the mind of the employers and unions that, well, hang on, actually maybe the deal that the employer's tabling isn't that bad, and maybe if I do roll the dice, I'm actually going to end up with something less at the end of the intractable bargaining process. That's really the view and the feeling that employers need to drive in order to get a successful conclusion to bargaining. Which again is a pretty handy segue to topic number 5, a related topic, and that is the trap of not having sound justification or evidence for the employer's claims or changes in positions in bargaining. Now, I want to take you through this trap by reference to a few examples. Let's take back pay, Nico. How might an employer justify its no back pay position? Now, this issue was a real focus in the recent Cleanaway series of cases that we mentioned earlier. And what the Fair Work Commission showed us is that where back pay is in dispute, the Fair Work Commission is going to have a really close look at what the employer's reasons are for adopting a no back pay position. And as part of that, the Fair Work Commission is going to have a really close look at how the bargaining process played out, when it commenced, why it commenced later or earlier than it might have. Was it the employer that perhaps had dragged their feet in kicking off bargaining? Is it the employer that is perhaps responsible for not giving the employees a chance to get a deal done before nominal expiry? Or does all this delay fall at the union's feet? That's going to be different in every negotiation. But what the Cleanaway cases make clear is that if the Fair Work Commission forms the view that the employer is responsible for some of that delay, then there is a very high likelihood the Commission is going to order back pay as part of any intractable bargaining workplace determination.
And if you think about the current circumstances, these are bargaining rounds that started in 2021, 2022, significant cost of living increases, significant inflation increases. Parties haven't been able to reach agreement, which is why we're in the intractable bargaining regime.
Yep.
So as time has passed, so back pay is going to be a pretty significant issue for most of these.
Absolutely. It's going to be live in almost every round. Well, particularly given that you actually don't get into intractable bargaining until 9 months post nominal expiry. And so employers are now on notice. You need an answer to these questions. Well, why do you say it's fair and reasonable that employees don't receive back pay? Not having an answer will lead to some pretty bad outcomes. The answer might be, well, actually, the employer's been pushing pretty hard to get this bargaining done. The union's been dragging their feet. They refused to meet with us. They refused to engage. They didn't meet deadlines imposed for responding to claims. It's a pretty common story in my experience. What's not common is employers calling that out properly, documenting it, and being ready to actually refer to that kind of conduct later on in the piece. So it's a real incentive for employers to get better at that, better at calling that behaviour, better at documenting it, and then setting itself up for a reasonable argument on back pay when it comes to workplace determination proceedings. That brings us to the second example that I want to take us through on justification, and that is, we've already talked about it, going to vote earlier on in the process. Now, many employers will want to and do take the position that, well, if this package deal isn't voted up this time, then everything's off the table. We're withdrawing all the concessions that we've made and we're starting bargaining again. Now, as we see from the Cleanaway series of decisions, that's possible. Network Aviation makes the point too. It is possible to withdraw concessions on claims, and if done genuinely, as you pointed out, Nico, then they won't be agreed terms that automatically flow into workplace determinations. But the very fact that it was put to vote in a particular way will be given some serious weight by the Commission in working out where conditions should land in the arbitration. So that's why justification, explanation, why is the employer adopting that position? Why were those conditions okay at the time of the initial vote, but not okay later? Why are those concessions being retracted? And it really does require a very specific answer in relation to each particular condition. Because absent a good reason or justification, then the Commission's simply going to say, well, you were okay with those conditions earlier on, let's just put them straight into the workplace determination.
Particularly where they've been endorsed by bargaining representatives. They might not be supported by the employees, but the bargaining representatives have endorsed an agreement being put to a vote, so it becomes hard to walk back from that.
Yeah, and the other component of this is also the good faith bargaining requirements. So retracting concessions without good reason may well be a breach of the good faith bargaining requirement to refrain from capricious and unfair conduct that undermines collective bargaining.
And going back to the old legislation.
Yeah, well, yeah, that's right. We're all familiar with those provisions. But it's a live issue. If you act without good reason and justification, it's the very definition of capricious. So employers, again, need to invest a bit more in this. It's all well and good to say that if you don't vote the deal up, then all these concessions are going to be withdrawn. Have a think about why. Why is that a reasonable position to adopt? And that will hold the employer in better stead when it comes to arguing these conditions in the context of a workplace determination. The final point I want to come to is wages generally. Now, that's perhaps one of the most difficult. Again, applying these same themes we've been talking about, why is the employer okay with a 2% per annum increase but not 4 or 5? In my experience, employers find that question very difficult to answer, but it requires an answer in the context of workplace determination proceedings. Absent having an answer to that question, you're going to land very close to what the union is seeking, in my experience. And that brings into play how might an employer respond to that question? How might it justify the 2% wage increase rather than the 4 or 5? And that brings us into some pretty sensitive territory. I mean, to do it properly, the employer is going to have to lead evidence about its market positioning as against its competitors, its return on capital, its profit, the impact that conceding to the union's claims is going to have on all of these factors. Now, you start talking about those very sensitive issues, naturally employers get a little bit nervous, and there's a real question that comes up quite frequently. Well, do we really want to be disclosing that information in the context of public proceedings? The reality is, if you apply a conservative lens and don't rely on that kind of material, you're going to result in some pretty poor outcomes, particularly when it comes to wage claims. And there are some things employers can do to protect the confidentiality of that material. The Commission, when there's good reason to do so, is very open to looking at things like confidentiality regimes, ensuring that only certain material is made available to legal representatives rather than the parties themselves. There's a whole range of mechanisms that can be adopted to reduce the concern that employers might otherwise have at disclosing competitively sensitive information. But these are things that really need to be thought about well in advance of bargaining commencement to do properly.
And that's not necessarily new. That's the good faith bargaining principles. If you put a position, you'd be able to justify it or answer a request for documents to justify a position. Not often used by either party, those good faith bargaining orders, but it's the same principle. If you adopt a position, what's backing up that position behind you?
Yeah, well, it's now that there's just more consequence for employers in not doing that work, because unlike the previous regime, you're more likely to actually end up in arbitration if you can't get a reasonable deal. And unless you are in a position to justify the positions that you've adopted through evidence at the bargaining table, then you're just simply not going to do well in the arbitration process. Which brings us to our final topic, Nico, the burning question. Is there any upside in the intractable bargaining regime for employers?
I think the short answer is yes, but there needs to be some work done to get to that position. So the primary benefit of the regime is, for example, it takes away that pressure of industrial action. So you don't have protected industrial action. It takes that off the table and allows the parties at least some period to negotiate with the spectre of arbitration going in the background. It's more of a release valve for the whole process, which it adds to the other release valves like the cooling off periods or the termination due to significant harm. It's just another avenue to bring the parties together to try and reach agreement. It's one that's got a timeline that attaches to it rather than sort of evidence about harm. So there is a benefit there. Again, it reduces the harm that industrial action might be having on the business on an ongoing basis. So if you've been suffering from protected industrial action for 9 months, you can't reach agreement, you can alleviate that damage to your business going forwards. And it also puts pressure on the parties to agree, because as you said, the assessment needs to be done by the bargaining representatives. If we go down this path, am I going to get a better deal from the Commission or not? It puts pressure on them to agree, particularly where you've got circumstances where the employees might be not aligned with the bargaining representatives. So it helps you get past that sort of stalemate sort of process. So there is benefits in going down this path, provided you've done the work and you understand what the consequences of having a workplace determination potentially being made are. So the things you need to think about is, can you outlast the protected industrial action? Can you endure it for the 9-month period? Is it something if you're working towards a workplace determination, is it something you can put up with for that period of time? 9 months plus, as we talked about, Commission involvement, putting to a vote, further protected industrial action. So it might not be 9 months, it might be 12 months, it might be 15 months, but can you endure that period of protected industrial action? Second point is, do you have, and Vic touched on, I think you did as well, do you have a strategy? What is your strategy to deal with existing terms and conditions in the EA? We can't go backwards, so how are you going to deal with that in terms of your bargaining process? We talked about justifying claims and trade-offs. And that's the other point. You need to be able to trade. If you want to make changes to the existing terms, you need to be able to trade for something else. What is it you are going to offer in exchange for the changes you want to those existing terms? Because if you don't get a deal on that, it just goes, the status quo just goes through as it is. And the second last point, I suppose, is what you talked about already, is justifying your claims. Justifying it to employees as part of the engagement process we Vic talked about, justifying it to the Commission in terms of evidence going forwards. What is it you can say to support your position? If we say that a 4% pay increase over 3 years is appropriate, why is it appropriate? And the last one, and again we talked about, is engaging with employees. This change to the regime, along with the other sort of changes to the Fair Work Act, really create a lessening of the leverage that employees would have had normally in bargaining. So can we go back to basic principles and engage with our employees, get them across the line. The bottom line is, you're right, as you said before, the aim is not to get a workplace determination. The aim is to get an agreement with your employees, and it's not even the bargaining representatives. Get your employees to agree to what you put on the table as part of a voting process. So as long as you deal with those 5 points, there is some benefit to it, but it's not going to be easy.
Yeah, but I mean, to Vic's point about employee engagement, what it does do is give employers a stronger incentive than ever to actually get back and properly engage with the workforce, understand what's driving them, understand what their concerns are, do the employer's best to address those concerns, but also explain from the employer's perspective where they're coming from in their claims, and do that properly, evidence-based justification. Use examples from the history of the workplace. Why does a particular condition or term or roster or whatever it is not work? Or how have we seen that play out in practice? And those sort of stories and narratives, building that up over time, to your point, Nick, Vic, not just doing it during the bargaining process is really important.
You get the trust in that way. And I mean, it's pretty clear that the legal avenues of leverage are not there, as it were, so you've got to go back to the traditional industrial relations, negotiation, engagement with employees.
Which obviously has bigger benefits, not just in the bargaining room, but for the workplace and your employee satisfaction generally.
Great. Well, thanks for those 5 traps and associated tips, Vic and Nick. Look, really can't emphasise enough how much this new jurisdiction has changed the tactics and strategy of enterprise bargaining, and therefore the way employers need to approach preparation. So, I mean, absent proper planning, it's pretty clear the outcomes are going to be worse than they were prior to these laws, but there is some real upside, as we've heard today, provided that employers are ready and make use of those opportunities. So feel free to reach out to your friendly member of the HSF Industrial Relations team if you do want to talk about these issues. We're very, very passionate about them, so very happy to have a chat. But in the meantime, we'd love to hear any feedback, as always, from our listeners. Feel free to comment, direct message or email us on insideir@hsf.com. Otherwise, we look forward to you joining us on the next episode of Inside IR.